The Supreme Court of India today heard an application filed by family members of the victim in the Arjikar rape and murder case regarding the investigation in the matter. We are being joined by Senior Advocate Karuna Nandy, who represented them before the top court today. Ma'am, before we move on to the application, I would like to ask you what exactly are the concerns that your clients and the parents of the victim in this case have with regard to the investigation, and what is it that they're demanding further?
Look, there were a number of circumstances in the incident that made it perfectly clear that it was not just this Shonjoy Roy who has been convicted who was involved. Because they were called and they were told that it is a suicide. They were then made to wait for a number of hours. The FIR was filed extremely late. So why? Why is all of this happening? The investigation, therefore, the further investigation, the CBI was conducting in any case. And the judgment that convicts Shonjoy Rai says very clearly that the CBI is conducting further investigation. So there's no doubt in anyone's mind that it is required. In fact, the Supreme Court was supervising this further investigation. However, what happened was that after the arrest of Dr. Shondeep Ghosh, who was the principal of RG Kaur College, and in many people's minds, the prime accused, right? As well as Mr. Mondol, who was the officer in charge of the Tala police station at the time of the incident, and therefore, accused of destruction of evidence because it's writ large on the face of this case. They were arrested. 90 days after that, the CBI did not file the charge sheet. Now, what does that mean? Under the Bharatiya Nyaya Suraksha Sanhita, it means that he was released on default bail. Now, they released on default bail with a 2,000 rupee surety and a condition that does not seem to prevent them from destroying further evidence. So, I think we were in a difficult position wondering why the CBI did not ask for stronger conditions. Why the charge sheet has not been filed. Why, and that was 90 days. Why after 180 days of their arrest that we still do not have a charge sheet. So therefore, what is very, very much required is a court that is the forum convenience, or that is the convenient forum. Examine this issue in depth. The High Court will have time. They will have the inherent jurisdiction to go into the matter in detail. The parents will be able to go directly to the High Court regularly, and they will be able to meet their lawyers every time in person. We were only able to meet online, and we were able to meet now in person. And they will be able to be more involved. So we really felt that the jurisdictional court is the High Court, and they would be able to also give more time. So we requested the Supreme Court to send it to the High Court. Now, we had already filed a petition in the High Court asking for the High Court to supervise the CBI's investigation, and the High Court was going ahead with the matter. There were 2 hearings that had happened, and they asked us to come and ask for a clarification. So that is why we were here. We were asking for the Supreme Court to essentially allow that to continue and to send this, when they had taken suo motu cognizance of the investigation and the entire case, to stay with the structural changes and the very important aspect of structural changes that are required in our hospitals and in our police and perhaps also in our judiciary in order to make sure that doctors are protected. I'm representing 25,000 doctors in that case. However, it was also very important for me and as counsel for the victims' parents to have the investigation aspect of the suo motu case sent to the High Court, and today the court has allowed it, and we're extremely appreciative.
So, your application that was before court today was essentially about transfer or basically monitoring of that investigation by a single judge of the High Court. That's what your submission was, and the court has allowed that to happen.
The court has allowed our entire application, yes.
Ma'am, On last occasion, we also saw the court ask you to get instructions and think about the fact as to whether this matter should continue before the top court or should it be disposed of, considering the High Court's already hearing it. Has there been a development on that aspect as well?
So we took instructions from the parents. Obviously, the application was prepared by briefing counsel on instruction of the parents, right? But we again took instructions, and the parents wanted to come themselves, and they were present in court today. And so that was also done.
Lastly, just we also saw during the hearing, Solicitor General for appearing for CBI had made a submission regarding some of the arguments in the application. Could you also clarify what was that confusion regarding? Because the court also corrected him and said something about how the first application had those submissions and that was withdrawn.
So there was an earlier application that was made, and that application had was asked for further investigation. But after that, the judgment came, convicting Sanjoy Rai. Right? So therefore, circumstances changed, which is why we filed another application. We withdrew that application and filed another application.
Thank you so much for speaking to us, ma'am. That was Senior Advocate Karuna Nandy. As we saw, the Supreme Court today gave its nod to the parents of the victim in the Arjigar case to go approach the High Court and seek the relief that they prayed for. With camera person Ashwani from New Delhi, this is Srishti Ojha, India Today.